Hi, my name is Anagung Bayu Calvin Alitawan. I am from Laos, batch 2018, and today on this video I want to tell you about verdict. What is verdict? So, verdict is decision are needed by judge on dispute examined and tried. Judge must be able to process data obtained during the trial process, both from the advice of letter, witnesses, accusation, confession, and oaths relevant in court proceeding. It's on Article 164 HIR. So that the decision to be dropped can be based on a sense of responsibility, fairness, wisdom, professionalism, and be objective. The verdict is the product of a case examination conducted by a judge based on Article 178 HIR and Article 189 RBG. After the examination is over, the judge, because of position, must hold a deliberation to take decision to be handed down. The examination is considered to have been completed if it has been through the response states of the defendant, a replica of the plaintiff, a duplicate of the defendant, proof and conclusion submitted by the parties. In deciding the case, the most important thing is the legal conclusion of the fact relevant in court. For that, the judge must explore the values, follow and understand the legal values and a sense of justice that lives in society. Source of law that can be applied by judge can be in the form of law and regulation, including the implementation rules, unwritten law like customary law, village decision, jurisprudence, science and doctrine, and teaching of expert. In the practice of civil justice, no legal source like Burger White Book, consisting of 193 article, BW is based on Article 1 of the Transitional Rules of the 1945 Constitution and still valid today. BW is valid for some Indonesian citizens, namely like those belonging to the Europe group and those belonging to the Tionghoa group, with some exception and addition as contained in the statute book of 1917 until 129, and those belonging to the foreign eastern group other than Tionghoa, with exception and explanation as contained in the statute book of 1924 until 556. Meanwhile, for the original Indonesian group, customary law, which has been applied for a long time among the people, most of which are still not written but live in the action of the people concerning all matters in the life of the people. Okay, that's all for me talking about verdict, and next they will be continuing with my friend Tony and Dapi. They will talking about exhibit.
Okay, my name is Muhammad Fernanda Hanafi, and here I want to continue about explaining about exhibit. The definition of exhibit is, according to Erzberti, what is meant by a proof is the process of proving and convincing the judge of the truth of the position put forward by the parties in a dispute before the trial. In civil procedural law, has a juridical meaning. First, give sufficient grounds to the judge who examine cases to provide certainty about truth of the purpose given. Second, only applies to litigation who have their rights. And next, I will explain about the burden of proof in exhibit. The burden of proof is must have done fairly. If in a dispute, only one party is given the burden of proof, while the other party does not, this will lead to a gap. Article 163 of the HIR states that if a person say he has a right or state an act to strengthen his rights or to deny the rights of another person, that person must prove the existence of the rights of or existence of the incident of the incident. And the evidence can be orally, documentary, or material. Types of evidence in civil procedural law, under Article 164 HIR 1866 of Burglary Quake Book. The first is written evidence, second is witness, the third is equation, fourth is recognition, and the fifth is oath. I'll explain about what is written evidence. Written evidence is a letter that regulates in Article 165 and until 169 HIR. The definition is, according to the law, document can be divided into certificates and other documents. A certificate is a piece of writing that is merely made to prove a thing or event. Therefore, certificate must always be signed. And second, certificates can be subdivided on official certificates, authentic and underhand certificates. And the second is witness. Witness is regulated in Article 169 until 172 HIR. Definition is, after verification by writing, verification by testimony is the most important means of proof in a case being examined for a judge. And the second is, a testimony must be about events seen with one's own eyes or experienced by a witness. So the witness must not only hear about event from other people. Okay, I think that's all about my explanation about exhibit, and the rest will be explained by my friend Tony Michael Ramasabun. Thank you.
Hello sir, my name is Tony Michael Ramasabun, and I will continue about the evidence. So the next is equation regulated in Article 173 HIR Article 9015 Civil Code. An allegation is a conclusion drawn from an event that is clear and clear. From this clear and apparent event, a conclusion was drawn that another event which has been proved had also taken place. In the proof, there are two types of allegations, namely the allegation set by law itself and allegation set by the judge. The second is recognition. Recognition regulated in Article 174 until 176 HIR. Actually, recognition is not means of proof, because if a party recognizes something, then the opposing party is free to prove that right. So it cannot be said that the other party has proven this, because the examination before the judge has not yet reached the level of proof. According to the law, and acknowledgement before the judge is a perfect proof of the truth of the things or even that recognized. This means the judge is forced to accept and assume an event that has been acknowledged has indeed happened, even though he himself does not believe that the event actually happened. The third is oath. Yahya Rahab in his book Civil Procedural Law on lawsuit, trial, confiscations, proof, and court decisions explained that an oath as evidence is a statements that is strengthened in the name of God with the aim of A, so that someone who swears in giving statement or statements is afraid of God's wrath when he lies. B, fear of God's wrath or punishment is seen as a driving force for those who swear to explain the truth. Oaths provide for in Article 177. According to the law, there are two types of oaths, namely decisor aid and supplementary aid. Decisor 8 is an oath ordered by the one of the parties that has litigated to opposing party with the intention of ending the case being examined by the judge. The second is if the opposing party takes an oath whose formulation is made by the party whose order the appointment of the oath, he will be warned. On the contrary, if he does not dare and refuse the appointment, he will be defeated. Whereas an additional oath is an oath ordered by the judge on one of the parties to the case if the judge believes that in a case there are already a beginning of the book, which needs to be supplemented with swearing, because it is considered unsatisfactory to render a decision on the basis of existing evidence. The judge is free to decide whether he will order an additional oath or not, and whether a matter is the beginning of the proof. Okay, that's all from my presentation about the evidence, and thank you.